Hi, I'm Brent Farley. I'm the managing member with Farley Law. We do regulatory work for financial institutions. And today I want to talk about how to handle shifts in the regulatory environment. Regulatory shifts are not a new thing. They've been happening for decades. But in light of some of the recent changes over the past year, and particularly in the last few weeks, with some of the new presidential executive orders, I wanted to talk a little bit about how to react and how to manage all of the shifting around in law and regulation that's happening right now. So just to point out a few items you might be aware of already, and to give a few examples of what I mean by dealing with some of the regulatory shifts. So January 20th and on 21st, we saw a couple, actually three executive orders that dealt with affirmative action and diversity, equity, and inclusion policies, both at the federal level and at the federal contractor level. And because banks have FDIC insurance, banks are going to be affected by some of this policy shift. So that's one example. Another example you also probably should be familiar with is Section 1071 changes. That's small business loan reporting. That section came into being quite a number of years ago now, but has been slow in being implemented. And once the CFPB tried to implement it, it's been back and forth between being stayed and paused and re-examined and reissued and stayed again. And so that's something else to be aware of. One of the other ones to think about also is Corporate Transparency Act. That one has been almost comical at this point. So we saw a period of time where FinCEN was working on implementing the rule. The rule went into place for reporting. They didn't quite have the reporting structure in place. Then they built the reporting structure and database to support the reporting. And then a few months later, we saw a lawsuit that put a stay on reporting. That stay was overturned. There's another lawsuit. Now there's a new stay. Currently, reporting is not required, but there's a fair chance that in a couple of months here, or even sooner, that will be unstayed and they'll have Corporate Transparency Act reporting again. So given this framework where we're seeing this flip-flopping and back and forth, how do you deal with that as an institution? And so just to throw this out there, it's not going to be easy. I don't think there's an easy way to deal with this all, but maybe here's a framework for a way to think about it. So we'll call this in 4 steps. This isn't a proprietary framework, but this is just hopefully an easy way for you to organize your thoughts around the issue. So step 1, well, let's understand the current state of the law. So what does the law say? Now, with something like overturning affirmative action policies by way of an executive order, it's going to take a minute to unravel all of that and unpack all of what that means. And this video is not meant to cover all of that topic. It just can't, because there's so much there. But you'll have to look at it from the perspective, okay, what can a president unravel with an executive order? What can a president not? And then try to take a step through all of the affirmative action-based and DEI-based policies and executive orders and things that have been put in place over the year. Peel those back and see what's left from a statutory basis. Okay, so that's understanding. That's how you would go about trying to understand where the current state of the law is. For affirmative action, you probably need some help from an employment attorney, from human resources folks who can dig into that and have a very thorough understanding of what exactly is happening. The next thing you need to do is have an understanding of where your organization sits currently in relation to all those policies. Are you in compliance with the law as it was immediately prior to January 20th? If so, then all you need to do is start working on making the shifts to deal with the current policy. I would say that with a caveat. You may not want to, at this point, take all of the previously existing policy and procedure and format and just throw it away. So I think there's a fair chance that in 4 years it might all come back. So in understanding where your institution is now, I think it's good to preserve the organizational knowledge that you do have. If you are shifting and changing policies, I would keep the old policies and put them somewhere where you can go get them later. Next up, when you're dealing with all these shifting changes and regulations is understanding where might the law end up being in a few months from now, a few weeks from now, or even in a few years from now. So as we've seen with the Corporate Transparency Act, compliance obligations have shifted back and forth over the course of a year, which is pretty short in terms of legal changes and law changes. And so if you're considering needing to report or not needing to report and what the deadlines are, make sure that you understand, I might not need to report today, but I might need to report later. And so you might think about what kinds of information you ought to preserve so that you can manage the reporting later. And also take a look at what agencies are doing in terms of extending timelines and in terms of their expectations for jumping back on board on reporting when that does come back around again. Another thing to think about is with affirmative action. With regulation, often we see a pendulum kind of effect with law and regulation where policy may swing to one side and may stay there shortly, and then it will swing to the other side over the course of years with the changes in administration and with the changes in government representatives. And so right now we've got a pretty hard swing in a particular direction. I think if you wait 4 years, depending on what elections look like, you might see a swing in the other direction. And it might be concurrent with, or maybe to the same extent as a swing in the other direction. So as you're making changes and you're looking forward, think about, okay, we have a rule now that says this. Is there a possibility that that rule might be paused in the next few weeks? Might it be paused in the next few months? Might it be overturned? Or what might happen in another election cycle if another group takes power and turns the whole thing on its head again? On how would you have to respond to that? So understanding where the law might go has become important. That may not have been quite so important in times past, because I don't think we saw such quick change and such, there's such oppositional change between administrations and to such an extreme extent. So it may be important going forward to take a look at, what are the different administrations they expect, and what might they expect in the future, and to leave yourself some flexibility in dealing with the policy changes. All right, last thing to include in this framework is have a plan of action and to monitor for changes. And so we're thinking about understanding what the current state of law is, understanding where your institution sits compliance-wise, process-wise, understanding where law and regulation might go, and then make a plan that deals with those potential changes and those potential results. So one thing that I've mentioned here is, if you're looking at an affirmative action type policy, you're looking at making changes to deal with the current federal policy, whether or not you see it as positive, it may be wise to keep a hold of the old policy and procedure, set it aside for a while, and you may need to dust it off later and bring it back out again. Similarly, with Section 1071 compliance, there is a final rule. Whether or not it's going to be enforced with the CFPB now being at least temporarily shuttered is an interesting question. But if you have done work on Section 1071, you've gotten prepared, you're partially prepared, or you're somewhat prepared, maybe take the prepared materials and process. And if you do feel like you can set it aside, but don't tear it up and throw it away because it might come back. So again, in regulation, we do expect it to shift back and forth, but the pace at which regulation has changed and law and regulation have shifted back and forth, particularly in the banking sector in the last few years, seems to have accelerated. So in terms of thinking about how do you deal with regulatory change, it may be wise to expand your approach just a little bit and think about, okay, now we know what law is, we know what the new law is and what it's going to be. Maybe also think about, okay, well, where might it shift in the future and what kind of flexibility should we leave ourselves so that we can deal with that when it comes up. Thanks again, Brett Farley with Farley Law. We'll talk to you next time.